morning. Before we begin, I will note that as we are sitting this morning, there shall be the funeral for Mayor Menino. So I do ask that each of us take a moment of silence to remember he who was the mayor of this great city for 20 years. Thank you. And with that, Fran, would you please call the first case?
SJC-11602, Commonwealth v. Gerald Russell.
Good morning, Mr. Brandt.
Good morning, Your Honors. May it please the court, Eric Grant for Mr. Russell. Your Honors, the defendant in this case was charged with 18 counts of statutory rape. The sole issue for the jury in this case was the credibility of the complainant's claims, which the defense said were fabricated. And the jury, by their verdicts, rejected the complainant's allegations of rape as to all 18 counts. The defendant was convicted only of indecent assault and battery as a lesser included offense on 7 of the counts, and those are the counts that are the subject of this appeal. Now, in our brief, we've argued 2 issues. In the second issue, we argued that it was error to instruct on the lesser included offense because it was not raised by the evidence. But in the time available this morning, I'd like to focus on the first issue in our brief, which deals with this judge's standard instruction on proof beyond a reasonable doubt. Now, it's the same instruction that the court dealt with a few months ago in the Figueroa case, where the issue was wholly unpreserved. But in that decision, the court specifically noted in a somewhat unusual footnote that the present case was pending and that the issue here is preserved, which it certainly is. And let me say a word about preservation. In this case, defense counsel objected to the judge's instructions on reasonable doubt and requested the Webster charge instead on 3 separate occasions. And one of them, in fact, was during the jury's deliberations when they requested the judge to, quote, elaborate the explanation of reasonable doubt. So this is directly an issue in the minds of the jury during their deliberations. But the judge rejected defense counsel's objection and her request for Webster at that time and both of the other times. So the issue here is, unlike the situation in the Figueroa case, is certainly fully preserved.
So let me just ask you, though, accepting that view that it is preserved, isn't the Commonwealth correct that it would be a harmless beyond a reasonable doubt standard?
We say no, Your Honor. The standard here should be it should be structural error.
Well, that's okay, fair enough. But I mean, it's fair enough. But it's a constitutional question. In other words, being preserved, it's in a different category than a preserved non-constitutional issue.
Yes, it is.
That's what I guess. That's really what I'm asking.
Right. I stress the preservation point because, as we know from the recent public trial cases, unpreserved error that's unpreserved will not be deemed structural error. So let me turn to the judge's instruction. The problem with this instruction was with the standards that it said, both for conviction and for acquittal. The instruction told the jury that they could convict if they were firmly convinced of the defendant's guilt. We say that set the standard for conviction too low. And he told the jury, that they could acquit if there was a real possibility that the defendant was not guilty. We say that that set the standard for acquittal too high. Now, we recognize that this instruction has been widely upheld elsewhere, mainly under the federal Constitution. And what we say about that is those courts are entitled to their opinion. Then again, so is this court.
It's a little ironic that the court, or certainly Justice Ginsburg in Victor, should think that the problem was it was too low. That is moral certainty language. Right? It's
a sort of odd state of affairs for those of us who are steeped in Webster and moral certainty and think of that as a very, very high standard. So I would agree with that. But in light of it being upheld elsewhere under the federal Constitution, we would like to focus today on our claim that the instruction was deficient under Massachusetts law. First, that it was erroneous under the state constitution, Article 12, the due process provision, which is the law of the land provision. Or secondly, in the alternative, that the instruction should be rejected under this court's supervisory powers.
Well, if we do the latter, will that help you?
Yes, it will, Your Honor.
And how does that help you?
Because under the Adjutant and the Pring-Wilson cases, the defendant in this case, would be entitled to reversal, even if the court is only rejecting it under its supervisory powers.
Do you
Why?
read, yeah, go ahead, sorry. You go
Why?
ahead.
Because the issue is fully preserved below by this defendant. It's being argued on appeal by this defendant. And under the analysis in the Pring-Wilson case, because it went to the central issue in dispute before the jury at trial. In this case, that would be the credibility of the complainant's claims. We say that the instruction set too low a standard, and if it instead set a proper, very high standard, they would have, they easily could have acquitted the defendant on all charges, instead of acquitting on 11 and finding the defendant guilty of the lesser included on the other 7.
Now, your brother points out that Adjutant and Pring-Wilson are the exception to the rule, and I think in that case there was language that there was serious concern about the justice of the verdict. Would that standard apply here?
It would, Your Honor, but I believe we meet that standard. The language in the Pring-Wilson case, which describes what this court did in the Adjutant case, said that that defendant was entitled to reversal because the error went to the central issue in dispute before the jury. The error here is in the reasonable doubt instruction, the standard that governs all of the jury's fact-finding throughout the case. So if they're
That's true of every single case. I mean, if you're right, I mean, it's always, by that definition, the definition of reasonable doubt is always the central issue in every criminal case, isn't it?
Yes, and that's why a supervisory rule that deals with proof, the instruction on proof beyond a reasonable doubt would be applicable to the defendant who argues it and preserves it below.
Mr. Brandt, do you take the position that if it's not broke, don't fix it? This Webster instruction, I take it that you don't agree with Judge Welch's article that it's extremely broken. In your brief, you noted that you hadn't had a chance to read it yet. Have you had a chance to look at it and to read his concerns? And I do like your metaphor, milk and cream. Maybe that's the problem.
Thank you,
It's
Your
too
Honor.
much cream here.
I have had a chance to read it, and it's discussed in our reply brief. One thing that sticks out about the article is that although he makes a devoted case to his new instruction, he also recommends that it be amended in his article. And the amendment suggests that after the firmly convinced language, that the instruction add abiding conviction language.
Which he didn't give in this case,
Which he
right?
did not do in this
Which
case.
is a problem, isn't it?
Yes, we believe it is. And as we point out in our reply brief, the judge, based on a transcript, a recent transcript of the judge's charge in another case, it appears that the judge has abandoned the firmly convinced language entirely and has substituted for that language a requirement that the jury be thoroughly convinced, which we would say is a lot more like it. And even that thoroughly convinced language is followed by the abiding conviction language to explain it. So yes, I have seen his article. I tried to get an advanced copy of it and was unable to do so. He makes a fervent case for this instruction, but in our view, the firmly convinced language simply is not strong enough to meet the constitutional requirement. And one can see that just by comparison to certain other language. For example, fully convinced. we can hear the difference between being firmly convinced and being fully convinced. And fully convinced is a lot more like what is required by the due process standard for proof beyond a reasonable doubt.
Of course, if you're right, we would essentially be saying that all the federal cases that relied upon Federal Pattern Instruction 21, which I expect could be many, are essentially convicting, in our view, at least under our Constitution, with less than proof beyond a reasonable doubt.
Well, if the court did that under the federal Constitution, I guess that's what this court would be saying.
But it
And we do not waive our federal argument. It's kind of a long shot, given the wealth of authority elsewhere. But we're asking this court to consider the history of the Webster instruction here and the importance of the due process provision of Article 12, and to reach the conclusion that the firmly convinced language is not constitutional as a matter of Massachusetts law, either under Article 12 or as a matter of this court's supervisory power.
I'm sorry, are you saying that firmly convinced is unconstitutional, or that firmly convinced without being bolstered by abiding conviction or moral certainty?
Well, we would say that neither is sufficient to satisfy due process under Article 12. Firmly convinced, in our view, is far less than what's required for proof beyond a reasonable doubt. Abiding conviction, that helps. To replace firmly convinced with thoroughly convinced, as the judge seems to have done in recent cases, that's a lot more like it. But I just see no reason to tell the jury that they have to be firmly convinced when the standard, we start out with a standard that's really much higher than that. Let me turn to the specifics of the firmly convinced language. In our view, the firmly convinced really sounds a lot like the clear and convincing evidence standard. It's firmly convinced, it's clear and convincing. They really sound pretty much the same. And whatever they might mean in their exact terms, they're both what we can see is they're both higher than a preponderance, but lower than proof beyond a reasonable doubt. And one state, Hawaii, has held that the firmly convinced language is erroneous under its state constitution on precisely that basis. It's too closely akin to clear and convincing evidence standard, and not sufficient for proof beyond a reasonable doubt. This is the, I'm sorry.
You finish.
This is the Perez case. It's cited in our brief.
Is your position that the firmly convinced in and of itself is constitutionally faulty, or is it in combination with the real possibility language?
We'd say either one of those things
By itself?
By itself is sufficient to hold this instruction unconstitutional. Hawaii focused on the firmly convinced language. It held under its state constitution that the instruction was unconstitutional. A decision from the Supreme Court of Wisconsin focused on the real possibility language, and while it held that language was constitutional, it rejected the entire instruction under its supervisory powers as simply as creating confusion about the burden of proof. That's in the Bennett case. That's cited in our reply brief. So as to the firmly convinced language, the problem is that proof beyond a reasonable doubt requires something approaching certainty that the defendant is guilty. The Supreme Court has said that it requires a subjective state of near certitude. This court has quoted that language with approval on several occasions. And what that means is that the jury, in order to convict, must be sure that the defendant is guilty, or at least as sure as human beings can reasonably be. They don't have to be absolutely positive. They don't have to be sure to a mathematical certainty. But the proper standard, in our view, is just one step shy of that. The jury has to be sure to a near certainty, or as we've said in Massachusetts for 160 years, to a moral certainty. So the problem with the judge's instructions, the instruction in this case is that it doesn't use the word certainty, and it doesn't require a proper degree of certainty. Not a near certainty, not a moral certainty, not an abiding conviction of guilt. It only requires that the jury be firmly convinced, and whatever that may mean, we see that as lower than the standards that have been held that I just mentioned, that have been held to constitute proof beyond a reasonable doubt. We've talked about the abiding conviction language. The amendments that the judge seems to have made to his instruction would be an improvement, but all that was used in this case was the firmly convinced language, and in our view, that's a significant step down from a proper instruction on reasonable doubt. The issue is fully preserved. The case is distinguished from the Figueroa decision. So we'd say that the instruction is constitutionally inadequate under the due process provision of Article 12. And I haven't even discussed the real possibility language, but I see that my time is up. So,
Counsel, may I ask you a question? You cited the Wisconsin case.
yes.
I don't see the citation in the index to your reply brief. Do you have the citation there? That's the case that focused on the real possibility language?
I believe it's State versus Bennett, and it's cited in the reply brief on page 14.
Okay.
I can give the court the cite if
No, well, if it's on 14, it's not in the index.
it's listed as
It's
State
Washington,
versus
actually, State versus
State
Bennett.
versus Bennett.
Yeah, 161 Washington 2nd, 203.
Washington second, yes, Your Honor.
But it's a
But you said
Wisconsin
Wisconsin.
case?
Did I say it was a Wisconsin?
Yes.
Yeah.
I'm sorry.
This is because it was cited in Lexis originally as WN, and I've been
I just
confused
didn't see a
about it ever
Wisconsin
since.
case in your brief, and I wasn't,
Sorry.
if I missed it.
We shall forgive your Eastern bias.
Thank you.
Thank you.
May it please the court, Kenneth Steinfeld for the Commonwealth. The citation for that case is 165 P. 3rd 1241, Washington Supreme Court 2007, which is also cited in the Commonwealth's brief. There is no state constitutional law claim before this court right now. The defendant appears to all but concede that under federal constitutional law, he's merely asking this court to disagree with the overwhelming authority of federal courts and state courts that this instruction does not violate due process. He made no objection below on state constitutional grounds. He merely asked for Webster, and I admit that the claim that the judge should have given Webster is absolutely preserved.
Mrs. Steinfeld,
Yes.
I mean, isn't that really, isn't it fairly clear from the beginning what the argument was?
Oh, no, I don't believe so. None of the Webster cases talk about Article 12, and the defense counsel below merely said, I want Webster. So I don't think that there's any Article 12 claim being brought. It has to be brought separately and specifically. And I point to the defendant's reply brief where his claim, he says that the claim is before the court because it would have been futile for him to object specifically on those grounds below because Judge Welch had made so clear of his intention that he was going to give his Webster instruction. So the defendant's own theory is that it is only properly before the court because an objection would have been futile, and that simply is not the law. When a trial judge makes clear, even very clear, that he intends to give a certain instruction, that does not vitiate the defense counsel's obligation to make a specific instruction. He still has to do it to preserve the record.
Specific objection?
Yes, I'm sorry, yes. Yes, objection. And he points to the futility case, the Vasquez case, which is on a whole other level. That merely says that when this court has made a definitive pronouncement that is later superseded by the U.S. Supreme Court, then it would have been futile for the defendant.
But shouldn't we reach this issue? Shouldn't we decide it?
Pursuant to Article 12?
Yes.
Well, the amicus solicitation in this case says merely whether or not this instruction given by Judge Welch suffices to define reasonable doubt under Massachusetts law. And I don't think the court should reach the Article 12 issue because it's not properly before it.
Well, do you agree that we could do it under our supervisory powers?
Absolutely.
But let me turn to the firmly convinced. I'm firmly convinced about a lot of things in my life. Brand X is better than brand Y. And I use that term in everyday language. I don't use abiding conviction in everyday language or a lot of the Webster-type language. Isn't it preferable that we use the Webster-type language because it lends an aura of solemnity to what the jury is about to do?
Well, I don't know whether it's preferable. I view the question as to sufficiency. This court may well hold that it's preferable to use the Webster language, and the Commonwealth has no problem with that, as long as it also finds that the instruction given here was sufficient, minimally sufficient, but sufficient nonetheless to convey to the jury the serious burden. Here, though, in Webster, we have more, in this case, we have more than just firmly convinced. The judge did give the instruction from Webster that involves, that it says a strong probability is not enough. And that combined with firmly convinced and the other language that he uses, I agree, firmly convinced.
He never used abiding conviction.
That's
correct?
absolutely correct. That's the only phrase that he did not use.
Well, and he never
that's
used the word certainty.
That's correct. But he did say that that a strong probability or possibility is not sufficient. You have to be firmly convinced, but if there's a real possibility, and I have set out virtually every federal court that has examined it under federal constitutional law has found that it does adequately state the government's burden.
Mr. Steinfeld, may I come back to your point that we shouldn't decide the issue? Well, there's a judge out there who is refusing to apply the law as most of us understand it, as most of us have understood it for a couple hundred years. So why would we ignore that when he writes a law review article and he says, I'm a contrarian? What's the case for leaving him out there to do what he's doing without comment from this court?
The answer is Hurd and LeBron, the two appeals court cases, both published opinions, both binding precedent, that say that Instruction 21 obviously does not violate due process. I'm not saying
but
that
that's the appeals court.
right.
not
I'm
the
just saying.
Supreme
I'm just saying
Judicial Court.
he's not totally alone out in the woods, as he even said here. This instruction has been approved by the appeals court, and I'm not saying that the court should not decide the issue whether or not the instruction that he gave is constitutionally sufficient. I absolutely think that that issue is properly raised and before the court. I'm saying the court should not address the issue under Article 12 because it was not raised. But I think that even if it does, he still won't win because he says the effect of an Article 12 analysis is that the question is not whether there's a reasonable likelihood that the jury found him guilty based on proof insufficient to dispel reasonable doubt, but he says that under Article 12, the proper analysis is whether there's a reasonable possibility that the jury so found. And this court has been quite clear in Figueroa and in previous cases in Dennis and in Pinckney that that's not the proper standard to be applied to a reasonable doubt instruction. The proper standard that this court has applied in the 90s, the 2000s, and now the teens is whether there's a reasonable likelihood that the jury believed that it could find the defendant guilty on proof insufficient to dispel reasonable doubt. So even if this court were to examine it under Article 12, there is no support for that being the standard of how to judge a reasonable doubt instruction.
But in terms of addressing the issue that Justice Hines has raised, I take it, as you say, you would have no objection to this court exercising its supervisory power in this respect.
That's correct, as long as it does so prospectively. As Justice Gantz has pointed out, I think that it is fairly clear that adjutant is the exception. It's an anomaly. It's a singular case, and that, as Justice Botsford pointed out, the argument for why it should apply here applies in every case. I've listed, I think, 5 or 6 cases, some before adjutant and some after, where this court has said because this is an exercise of the court superintendent's powers, comma, therefore it shall apply solely to cases tried after the rescript in this opinion.
I just don't want to leave something on the table just without.
Certainly, Justice Duffy.
Hurd and LeBron, don't they also, the instructions, don't they have additional instructions? The abiding conviction and moral certainty, both of those cases involve more than just.
Yes, but the holding, if you look at Hurd.
You can't really ignore the fact that the actual instructions used other language, can you?
Well, I think that if you look at Section 1 of Hurd, it does not discuss the abiding conviction language at all. It solely discusses Instruction 21 without the abiding conviction language, and it says this obviously does not violate due process. The court in Hurd did not even mention the abiding conviction language until Part 3 of its opinion, after it had already held that, absent the abiding conviction language, it still did not violate due process. So yes, I agree that in those cases there was abiding conviction language, but that was not part of the court's analysis, the appeals court's analysis, when it reached the decision that the absence of that language did not violate due process.
Let me turn to the amicus from Mr. Phillipson. Is there a point that there is a moral quality to proof beyond a reasonable doubt, and that this instruction simply gives it a mathematical quality?
Well, I read his amicus brief with some interest, and I frankly find it quite academic. There is, of course, a moral...
That doesn't mean it's bad.
No. I did not mean to demean it by saying that. There is a natural moral element sitting in judgment of someone else, and I think the procedures that are in place to impart on the jury the gravity of the situation does not have to be through the vehicle of a reasonable doubt instruction. In Judge Welch's case, he makes the witnesses stand, he explains to the jury the history, and there's no question that through his instructions and through most instructions made by trial judges throughout trials, imparts on the jury the difficult task that they are about to undertake. But I think that the word morality is a double-edged sword today as to what that means. That could ask a juror to bring to the table his own preconceptions of what is moral and what is not. He might find conduct immoral but not illegal, or vice versa.
But doesn't moral have a historical meaning, an antique meaning? I don't mean...
Absolutely.
It's different than what you just described.
Absolutely, but I don't think to the modern juror. I think that the modern juror does not come to the table or to the jury room or box with an understanding of the historical meaning of that term. Same as the term moral evidence, which was for a long time part of the charge. I don't think almost anyone today would understand the difference.
But don't you think, though, that yes, there's lots of pieces of the trial that make a juror aware that it is a very great responsibility to judge one's fellow human being. But Justice Spina's point seems to me to be well taken, that particularly in the burden of proof, using language that is specifically stressing the gravity and the depth of what you are being asked to do, as opposed to using everyday language that suggests the kind of decision. I mean, it's sort of a, I think his point is that even firmly convinced could be seen as falling on the side of why you can't use, it's the doubt, the lack of it is when you're making a very important decision in your life, like buying a house, or, trying to get away from that, tying it to everyday things.
Right, those were certainly problematic instructions, and I'm glad, frankly, the court has moved past that.
Right, but I think that Justice Spina's point is that this kind of language makes that even more clear, that this is not an everyday thing. And the problem with firmly convinced is that it sort of leads you back down the everyday path.
Well, but you say that it makes more, it's already, I think there is sufficient, and I have no problem with adding to the instruction that this court approves some language that imparts the grandeur and the importance. It's certainly fine to have it in the reasonable doubt instruction, and I think that it would be a good place to have it. I don't think that it's necessary, that it's constitutionally sufficient demands that it be there. But I definitely agree that it is certainly, I mean, as I say, and this court has held, it is the most important instruction at a criminal trial, because everything else depends on it. So it certainly would be a very good place to insert some language that does that. I don't think it has to be there. I think the rest of the trial, provides enough. There probably cannot be too much, because it is such a serious matter to sit in judgment in a criminal case of a person, but I absolutely don't think that there's any support that it has to be within the reasonable doubt instruction for the instruction to be sufficient under Massachusetts law.
Can I turn to the indecent assault and battery?
Yes, of course.
The judge said 8 of these. I know one of them didn't get on the jury.
Yes,
slip,
yes,
but
correct, absolutely.
8 of them, there was sufficient evidence to find that, and it seemed to be, I haven't read the transcript, so I'm sort of going on what was in the briefs, but it seemed to be from maybe the age when these things, of the complainant when these things were happening. And is that the case?
He did take that into account, and that is what he explicitly stated as one of the reasons why the jury may believe that there was no penetration, but believe that there was some other kind of sexual contact. That is what he focused on, yes.
Because the latter portions of these, I mean, I know that the indictments are grouped by time frame.
Age-based.
Yeah. But I think we get into like 85, 86, maybe, some of the indecent, which is getting up to, almost up to 89, which was the end point. So I just was trying to figure out how that was all working.
Well,
It wasn't, in other words, was it really age, or was it the specific things the specific description that she gave of each of these events?
it's a combination of things. As to the 4th and 5th the 5th and 6th indictments, we're only talking about the first 4, where the judge instructed on the lesser included, and I believe they go through when the victim was 12 or 13. I'm not absolutely
Yeah, that
sure.
sounds about
Following
right.
that period, she testified that it, quote, escalated into full sex. And by that, the jury and the judge even said that the jury might have inferred from that prior to that, in part because of her age at the time that the events had passed, that there had been no, quote, full sex, which could have been her way of saying there was no penetration. On top of that, I think that the instructions were perfectly proper, because the defense put on a lot of testimony that showed that the victim had a very, very strong motive to testify falsely against the defendant. That is, that he had been so abusive to her mother. Therefore, the jury could have found that there was some sexual abuse, but because of her anger at the defendant, the way he treated her mother, she had exaggerated the extent of it. So there certainly was a basis in the evidence for the jury, at least as to the first 4 indictments, for them to say, well, we don't believe her as to penetration on those 4 because she's got an axe to grind. And they found him not guilty of all the charges that occurred after that. So I think the evidence certainly supported, and Porro, this court's decision, takes a very broad view of the circumstances in which an instruction on the lesser included is proper, and it even discusses the sort of situation here where there's a young victim of child sexual abuse, and the jury can either disbelieve or believe the evidence of penetration. I see my time is up. I thank Chief Justice for the extra time, and I rest on my brief.
Thank you, counsel.